Folks, good morning. We are on the record today now for the 28th Circuit Court for Missaukee County. And we are taking up first today the case of People of the State of Michigan versus Gordon Dale Mosier. This is file number 22-3286 FH. Appearances, please.
Thank you. David Denhout on behalf of the people.
May it please the court, Robert Champion appearing on behalf of Mr. Mosier, who's seated to my left.
Thank you. The court also recognizes before it today Mr. Luke Blazak, who is an agent from the Michigan Department of Corrections, and prepared the probation violation report, also known as the CFJ 491. We're here today for sentencing after a probation violation. A finding of guilt as to two probation violation allegations. Mr. Denhouten, have you received a copy of that probation violation report? And if so, do you have any amendments, corrections, or objections to raise today?
Thank you. I have received the report. I've reviewed it and I have no proposed corrections or additions.
Thank you. Mr. Champion, same question.
We have reviewed the report. We have no additional corrections or additions.
All right. Allocution then, Mr. Champion.
Your Honor, this is a unique situation. I've dealt with this case, as the court has, for quite some time. I've dealt with Mr. Mosier for quite some time. Who I was dealing with in the beginning is not the man I'm dealing with right now. He has accepted responsibility for his actions. One of the things I would note, though, in his eviction, and most recently he brought up, after spending a considerable length of time in jail, he got out and he was without support, housing, or places to go, and he fell back into the situation, which is noted in the report, running with people that he ran with before, which resulted in these two violations. I would ask the court if the situation, given the place that Mr. Mosier's in, the fact that he is accepting responsibility in this particular case, he understands what he's done, and he's willing to do whatever the court says. I would ask the court to consider terminating probation with time served. Thank you.
Thank you. Mr. Denhout.
Thank you, Your Honor. As the court is aware, the original sentence in this case was 365 days. I believe there's been at least two prior sentencing with respect to probation violations that have also ordered 365 days. So simply, Mr. Mosier is out of jail time. The prior violations included use of methamphetamine on at least two occasions, failing to attend treatment. The current violation is failing to test and not being in an approved residence. As the court is aware, because we did have a hearing, the defendant's girlfriend had methamphetamine on her at the time, and again, he was at an unapproved residence. Clearly, Mr. Mosier has been struggling with substance abuse addiction for some time. He is a personable individual, so there's certainly some things to note in terms of his credit. But frankly, the people have, just based on the history of Mr. Mosier, do not have a high likelihood for optimism in terms of a future outcome. The recommendation is 23 to 120 months. The people do support that recommendation, and we would leave it to the discretion of the court.
Thank you. Mr. Mosier, you have the right to make a statement today before the court issues a sentence. Is there anything you wish to say today, sir? No, Your Honor. Mr. Blazak, I'm looking for it and I should be able to find it quickly, but what was the original guideline range?
10 to 23, Your Honor.
All right, thank you. That's what I thought it was, either a 5 or a 10 to 23. Well, since we had our hearing last time, one that we had just before that, which I think was back in November, I have.
Your Honor, I misspoke.
I'm sorry.
5 to 23.
All right, there we go. I knew it was one of those, but thank you. All right, I have struggled a bit on what to do with Mr. Mosier. In some respects, as Mr. Denhouten said, I agree. He can be quite personable. While I think that's an appropriate comment to make, I don't look at sentencing always as judging a person's personality. And I'm not criticizing you, Mr. Denon. I'm trying to explain what my sentence is and my thought process. My thought process is not always about punishment either. It's about being hopeful. It's about deterrence. It's about holding people responsible. It's about setting objectives for people and seeing how they respond to them. And while I understand the full history here of this file, and then I know there were some issues regarding competency, and those were addressed and taken care of. I think of a person here who struggles with substance use disorder and with complying with the rules. We had extensive problems or challenges with the defendant while he was on bond, including testing positive for controlled substances. We've had a continuation of the defendant testing positive while on probation. And we've also had other challenges with the defendant in complying with probation. To be quite honest, one of my thoughts was to have a finding and then think about what to do, but it was also maybe to allow the defendant to earn some credit and maybe potentially just give him time served. But I can't do that. This is a defendant who has struggled and on his own, or even with the help of probation, can't seem to comply. And this court has a challenge before it, and that is we give people chances and we give people rehab. We give people the opportunity to try out. We give them testing. We allow them to have bond. Of course, that the people aren't punished, so I'm not making a negative statement about bond, but while they're on bond, we give them sometimes treatment. We also do testing to make sure that they're compliant. I cannot think of another example where in recent cases where we have had a defendant struggle to this degree and been given so many chances. The court hereby sentences the defendant as follows. Again, based upon the information that's contained not only in the original pre-sentence investigation report, but also highlighted in the probation violation report, the CFJ 491, the comments that I've made regarding the repetitive violations, and the fact that this is not an intermediate sanction cell. The court does not need to find reasonable grounds, but I do need to make statements as to why this sentence will be or is proportionate. And again, when I look at the defendant's extensive prior criminal history, which a lot of it deals with controlled substances, I see probation being terminated unsuccessfully at least once, if not multiple times. The defendant has had extensive opportunities for rehabilitation. The court hereby terminates probation unsuccessfully and sentences the defendant to a prison term of 18 to 120 months and grants the defendant 364 days of credit. Was that the right amount of credit, Mr. Blazak? Yes, I see that it is. All right. The court preserves all fines and costs, and I think I've covered everything. Mr. Blazak, have I missed anything, sir?
No, thank you.
Thank you. Mr. Mosher, you're receiving 2 copies of one document. You will place your initials on the first copy. Place your initials neither elects nor waives any rights. It merely acknowledges receipt of the other document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case originally, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you complete the bottom half of the document and return to the court within 42 days. Do you have any questions about those rights, sir? No, Your Honor. Mr. Mosher, I cannot stress enough, you need to change the people who you're hanging out with and change the lifestyle. And I don't say that you don't have to. I'm not going to supervise that anymore. You really need to make some better choices, at least for yourself. And I really hope that you do, because when I think of sentencing, I don't always think of it as being a punishment. I think of it as actually trying to be hopeful. Thank you. We're adjourned. Okay. We are next taking up the case of People of the State of Michigan versus Dale J. Herwire. This is case number 23-344FH. Appearances, please.
Thank you, David Denham on behalf of the people.
May it please court Robert Champion appearing on behalf of Mr. Herwire, who is standing to my right.
Thank you. You may be seated. The court also recognizes before this morning Ms. Laura Liddell, the agent from the Michigan Department of Corrections, who prepared the pre-sentence investigation report in this case. The court has taken a look at that document and notes, at least the only change that I saw, and maybe we'll find some more, is on the SIR 88-1, which is the cover page, and the docket number is incorrect. It should be 3444, not 40.
Thank you.
No problem. Thank you. Mr. Denhausen, have you received and gone over a copy of that report? And if so, do you have any amendments, corrections, or objections to make, sir?
Just one minor addition, Your Honor. There is a restitution request. I think it's referenced, but not the amount. The people are requesting restitution in the amount of $289 for Paul Barker.
I'm sorry, that name again is Paul?
Yes, Paul Barker, Your Honor.
All right, thank you. Any other, besides that note, anything else, Mr. Denhausen?
No, Your Honor.
All right. Same question to the defense, Mr. Champion.
Your Honor, first of all, we have no objection to the amendment. My client agrees to that. Additionally, we have no additions.
Thank you. By the way, I will note that the court did receive and read in its entirety a statement provided by Harbor Hall's social worker or counselor that was assisting or has been assisting Mr. Herwire. I did read through that. And that again was presented to the court a couple days ago on January 10th. One moment here. Sorry for that delay. I just wanted to review some of my underlined notes. Mr. Champion, allocution, sir.
Your Honor, this is a situation where my client has had a very long history of substance use disorder. As you can see by his criminal history, high BACs. We're not talking about, low. They're in the 20s and higher. My client recognized that. He recognizes that he has a severe substance use disorder and he is dealing with it. He's doing extremely well right now in Harbor Hall, as indicated by the letter we received from them. What's interesting about Mr. Herwire is that he recognized when he woke up in jail, he was going to be in jail, okay? He knew it, but he also recognized that if he didn't change his life, he wasn't going to be around much longer. So he took his own action. He got into this program and he's fully committed to that program. I would argue if you take alcohol out of my client's life, he would have little to no criminal history. So at this time, I'm asking the court to allow my client to continue in the program as outlined, place him on a term of probation. And I think we can have a true success story if that's allowed. Thank you, Your Honor.
Thank you. One moment, Mr. Denhausen. Mr. Denhausen, thank you for your patience. Anything further?
Thank you, Your Honor. Yes, on this one, Your Honor, the people are respectfully diverging somewhat in the recommendation from the probation department. The people are requesting there be a prison commitment in this file. It should be noted that the defendant did receive a benefit in the guidelines He did plead OWI third as a half second rather than a half fourth. So the guidelines are 10 to 28, but clearly a prison commitment is well within the guidelines. And even in the middle of the guidelines there, a prison guideline would be appropriate. It's the people's opinion that have no doubt that Mr. Herwire is a pleasant person when he's not drinking, but I think the record will bore out the fact that when he does drink, he becomes aggressive, he becomes somewhat violent, many assaultive type of convictions. But the long-standing history of defendant drinking and driving, making the decision to drive while drinking after having drinking a considerable amount is evident in the defendant's record. Looking at just the OWI convictions in 2003, he was convicted of OWI third. He spent nine months in jail. At that time in 2008, he was convicted again of OWI third as a half second. He received a 24 to 90 month prison commitment then. In 2013, he was convicted of OWI second. He received 6 months in jail. In 2015, he received, there was conviction of OWI third again, another felony conviction. He received 365 days jail. Somewhat ironically, he was released early to Harbor Hall, the same residential treatment that he currently is attending. Respect the fact that he appears to be benefiting there, but again, the same residential treatment. 2021, another felony OWI third conviction. At that time, he received 10 months in jail. So just a history of many, not just OWIs, but OWI felony convictions. This incident happened September 16 of last year. Paul Barker initially went out there to assist at the location where he went into a ditch. Defendant became somewhat verbally abusive. He went back and Mr. Herwire then attempting to get the homeowner's attention, banged down the screen door, damaged it significantly. Mr. Barker was so concerned that he got out a gun for protection in case he would enter into the home. So had not law enforcement arrived when they did, the incident could have been very significant. And just looking at the blood alcohol content of this particular incident, 0.249, way multiple times over the legal limit. So for all of those reasons, the people are respectfully requesting that Mr. Herwire be committed to Michigan Department of Corrections.
Thank you. One moment, please. I don't know why I do this. Sometimes I miss it and I forget. I always mean to put more flags on these PSIs, so it reminds me. I'm going to direct your attention, or the council's attention, to CFJ 284A. And we're looking at page 14, and we're looking at criminal history 18 of 19. The status at the time of the offense right now says none. That's incorrect. He was on probation at the time for the offense just above that. Mr. Herwire, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say today, sir?
I will not deny anything that has been said in regards to an extensive history due to alcoholism, substance abuse. I've tried various things to change. I'm guilty of everything that has been presented before the court. I'm here to hold myself accountable. Something happened in Harbor Hall. I don't understand if there's a readiness in somebody who's eventually had enough. Mr. Champion said when I got in there, I knew I was going to go to jail. Actually, in all honesty, I thought I was going to prison for sure, and still, it's very likelihood. I had no hope. I was sick and tired of everything. I was seeking out treatment prior to me being incarcerated, and seeing how I insurance, I can get state funding to help. My work was even willing to give me 60 days. Apparently, to get current funding, you have to have nothing to go to a place like that. I can't say enough of what that place did as far as opening up my eyes and opening the doors to success. Obviously, somebody's got to be willing to do it. You got to be open-minded. You got to be honest with yourself, and you got to be willing to do the work. Unfortunately, it's taken me this long to grasp that concept and embrace it. But I'm at the mercy of the court. That's all I got.
Okay, thank you. One thing that we talked about today is the restitution. I don't know how I can order restitution. That wasn't the victim of the crime. I don't think lawfully I can order any restitution, right? The car was in the ditch. It's not like he hit somebody. I know that according to the information, he went and knocked on a door and broke some glass or something like that. I don't know. I don't think it's lawful for me to order restitution.
Your Honor, he was charged with malicious
Was
destruction
he?
of property,
Oh, you know what? Thank you.
And
I
that-
should have looked that up.
and that was dismissed as part of.
There we
the
go.
plea bargain.
I see that. Thank you. All right, well then, all right. So I'm glad I addressed that. Mr. Denhousen said a few things that I also had circled and checked. You know, I often look at how people have dealt with issues involving substance use disorder in the past. And I circled Harbor Hall, and that the defendant spent 3 months in Harbor Hall back in 2015 to 16. That's the same program for which we have here a letter today. I see that the defendant spent, looks like 2 months involved in Catholic Human Services in 96, 2 months with the same program in 98 to 99, 2 months again in 2002. According to this, there has been no end to his attendance at AA. I put that circle on there, which means he's continued to use AA for the last 20 years. And I appreciate and respect that. And it definitely shows somebody struggling with substance use disorder. I see the Stay and Quit program for, it looks like maybe up to a year. I see another month in addiction treatment services. I see more Catholic Human Services in 2008. I see 3 months in the Nexus Family Services in 2011, and the WRAP program as an alternative to prison in 2008. I stopped counting after I saw at least 9 alcohol-related offenses beginning as minor possessions. I see the defendant has been convicted previously of operating while intoxicated as a 3rd offense. I see that the defendant had a 0.249 blood alcohol level. I see that the defendant has had multiple chances at probation and has had multiple failures in probation where it's been terminated. I see multiple convictions where the defendant has committed other crimes while on probation or while on bond. And I see one case in 2006 where he had a 0.299 blood alcohol content. I see cases where the defendant has had other offenses where he served up to a year, 10 months, 365 days here and there. And I can see that it hasn't had the necessary impact that we would like. And I do greatly appreciate that the defendant has put himself into rehab on his own. That is not going to belie the court's objective here and its responsibility. Mr. Herwire, this sentence I find is appropriate based upon all the information that I've just discovered or discussed. This report is chock full of your substance use history, and it's chock full of chances, time and time again. And it's also full of you not taking advantage. So As far as it comes with me, this recommendation, and I respect and appreciate Ms. Odell's recommendation, is nowhere near appropriate. Your time of drinking and driving needs to be done. So
I agree.
this court sentences you to a $68 state minimum fee, $130 crime victims' right fund fee, $288 of restitution payable to Paul Barker, $300 court cost, a $500 fine, which I believe is the mandatory minimum, and an attorney fee of $300. The court also finds that that amount is fair and reasonable considering the defendant's criminal history and the case involved. I'm sorry, this particular case, his history, his substance use history, his chances after chances. And that money will begin to be collected from your accounts at the Department of Corrections. The court chooses to sentence the defendant within its discretion as a second habitual felony offender. The court sentences the defendant to a prison term of 20 to 90 months and grants the defendant 34 days of credit. Have I missed anything, Ms. Odell?
Your Honor, I'm just wondering if there should be a $100 OUI fee.
Oh, there's $100 OUI fee. That's for the prosecutor
To the
or
sheriff.
to the sheriff's department. Thank you. The $100 OWI fee to the sheriff's department, which is a government response, and that's permitted underneath the law.
John, was that 22 or
20 to 120. Sorry, a range beginning at 20 with a dash to 100 to 90 months. I think it's 7.5.
Was restitution 288 or 289?
288. Wasn't it 288?
289.
I'm sorry, 289. Thank
Thank
you.
you.
I didn't mean to shortchange anybody a dollar. Mr. Herwire, Mr. Champion is bringing to you a document, and there's 2 copies. You are to place your initials on the first copy. Neither your signature initials does not waive any rights or elect any rights. You are merely acknowledging receipt of this copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you complete the bottom half of the document and return to the court within 42 days. Mr. Herwire, you're still quite a young person, and you've got the opportunity to overcome this period of time. My father had an issue, and some people have heard this, and I say it not to talk about me, and it's nothing to do with me. Well, when he passed away a year ago, one of his probation officers appeared and spoke and said he finished well at the age of 74. You can still finish well, and you can do well by stop drinking. Never pick up another glass, never touch a bottle of beer, never. And if you do, get rid of your cars. Never own a vehicle. Thank you. We're adjourned. We are next taking up the case of, oh wait, was that her that just stepped out with Mr. Champion? No problem. We are 7 minutes ahead of schedule. That's okay. We are next taking up the, I'm sorry, Mr. Champion, are you ready? I know we're 6 minutes early. Oh, we gotta wait for the prosecutor to show up.
I am ready though.
All right, one moment. Oh, sorry, Mr. Denham, I just got enthralled in reading. All right, we're going to take up the case now of People of the State of Michigan versus Holly Lynn Lopez. This is case number 22-3293 FH. Appearance, please.
Your Honor, David Denhout on behalf of the people.
Good morning, Robert Champion, appearing on behalf of Ms. Lopez, who's seated to my left.
Thank you. Court also recognizes before it this morning, Ms. Laura Odell, the probation officer. In this file, we're here today for a sentencing on a probation violation. There is a CFJ 491 attached to the original pre-sentence investigation report. The defendant was originally sentenced back on September 27th, 2022. The court has gone over the new CFJ 491. Mr. Denham Have you gone over it? And if so, do you have any amendments or corrections to make or objections?
I think, Your Honor, the people have received the report, have reviewed it, and there is no proposed corrections or additions.
Thank you. Same question to the defense.
Your Honor, the CFJ 491 under the recommendation, so the court's aware there are no new charges in Wexford. And Ms. Lopez is set to enter a plea on the Grand Traverse case on the 19th of this month.
Right, so let me go ahead and add some information there, Ms. Odell, that says no new charges have been filed in Wexford County, and the charges in Grand Traverse County will be resolved later this month. Is that right, Mr. Champion?
That is correct, Your Honor.
Thank you. One moment, I need to review something. All right, thank you for your patience, Mr. Champion.
Your Honor, as the court can see in the pre-sentence report, my client has completed a residential treatment program that was completed on the 17th of October. This is the third case we've had that in a row that deals with substance use disorders. My client acknowledges that she has a substance use disorder. She has a very limited criminal history, and she still struggles with it to this day. I would ask the court to consider terminating her probation with time served.
Thank you, Your Honor. Clearly, Ms. Lopez has been struggling with substance abuse disorder. To her credit, she's acknowledged the issues that she's had. She did plead guilty to the recent probation violations, which include possession of prazolam and fentanyl. The original conviction in this case was possession of methamphetamine. As noted in the report, she did abscond for a period of time, and there are pending charges in Grand Traverse that appear to be resolved or will be resolved shortly. Given the history of this case, the people do support the recommendation to terminate probation, and we do believe that an additional jail term would be appropriate. We would leave that to the discretion of the court. Thank you.
One moment. Ms. Lopez, you have the right to make a statement before the court issues a sentence. Is there anything you wish to say today, ma'am?
I would just like to apologize for my actions and the trouble that I've caused for myself and my family. And I just want to get this put behind me and get back into the community and keep my right foot forward and doing the right thing.
Thank you, ma'am.
Thank you, Your Honor.
I appreciate that you went and participated in the rehab program. And the court allowed you on bond to do that program. Now, I always wonder what people think the court is going to do in that situation. One, I could reward the person and say, good job, no further time. I'm not saying that's not a bad idea. However, I look at it this way as well. The other argument is I allowed you to go do what you needed to do. And did I allow the fact that you could get further punishment help encourage you to go get the rehab? Yes. When I allow people to go to rehab, I'm recognizing that bonds is not to be used as a punishment, but I also recognize that bond can be used to encourage people to do rehab, which, by the way, clearly in this instance, you need to do. So you are doing it, not for me, but for yourself in these situations. So now I look here at this offense and I look at prior criminal history, which was not all that extensive, but I mean, there is some criminal history here. And I don't think I saw any probation violations. I did note in circle one that I thought was interesting. One moment. Actually, it was just a series of them back in 2002. They were all bunched up together. But anyways, I'll digress. You're not only hanging around people and involving your life in controlled substances. I want this clear. I put you on probation and give people a chance. I want people to take that chance. When they don't, they fully know what they're doing. I think it's a person sometimes asking, I should get more jail. And the answer is you should. So when you are on probation and you go out and violate probation, particularly in the way that you did here, you know that if you get caught, you're asking for more jail. So therefore, I'm going to give you what you asked for. I'm going to terminate probation unsuccessful, preserve any fines and costs. And while I'm not required to, under the law, to stay within the guidelines, I'm going to give you the full 330 days with 150 days of credit. Now that's going to impact you because you're no longer earning credit on whatever you might be getting in another case, you know, so you're going to be sitting in jail and that's not going to help you on your Grand Traverse County case. Have I missed anything, Miss Odell?
No, Your Honor, thank you.
Ms. Lopez, Mr. Champion is bringing you 2 copies of 1 document. You are going to place your initials on the first copy. Place your initials neither accepts nor waives any rights. It merely acknowledges receipt of the other document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. Because of the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you simply dispose of the document. Now, the last things I want to say are actually a positive. Because clearly I know, or sorry, I don't know. I don't know what's happened in the Grand Traverse County case, but Mr. Champion suggests it might be resolved, which I interpret to mean maybe a plea or a trial.
It is a plea. Your Honor.
And my point there is, let's look at this with a positive note. You are a young person. You have got the opportunity to put your life in the right direction. I can tell you that I looked here at the names of the people involved in this case, and the answer to me was, well, duh, you got in trouble. Right? I mean, these names are people we all know in this courtroom. Do better choices, make some better choices. Ms. Lopez, you've got qualities that, I mean, you've always been polite here in the courtroom, so there, and I look here, and you're not violent and things like that, and you're not, I don't remember seeing any drug delivery charges. Let's put this life behind you. You're younger, not longer, significantly younger than I am, and you've got plenty of time. I really want you to take this time and think positively about where you want to go.
Yes, Your Honor.
Thank you, ma'am. We're adjourned. All right, we are next taking up the case of People of the State of Michigan versus Scott Suter. This is file number 18-2966FH. The court recognizes before today Ms. Laura Odell, probation officer on this case. And now before the court is an individual seated at the defense table. Sir, are you Joshua Scott Suter?
Yes.
Thank you. If I said Sluter earlier, I apologize. There's a smear on one of the
You did
forms.
it good.
All right, thank you. Mr. Suter, we are here today for what's called a show cause. We could also call it an arraignment. It's because there's been filed a request and summons, not a warrant, but a request and summons for a probation violation. I need to tell you what that allegation is, what your rights are, and the possible consequences, and then see how you wish to respond. It says that allegedly on or about November 8th, 2023, you failed to comply with the verbal order of your field agent. Specifically, that you went to an address at 121 West Wexford Avenue in Buckley after being verbally told not to do so. Now, that would be allegedly a violation of your probation in this case for failing to comply with verbal orders given to you by your probation officer. You have the right to challenge a single count in a hearing. That hearing would be conducted within 14 days from today's date. At that hearing, you have the right to be represented by an attorney as well as in all subsequent proceedings. You also have the right to review any evidence presented against you, question and cross-examine any witnesses presented against you, as well as to present witnesses, evidence, or testimony if you chose to do so. Obviously, if you chose to remain silent, nothing could be used against you for that choice. If you're found to be in violation of your probation, you would be resentenced on your original offense. In this case, you were originally convicted of attempted criminal sexual conduct in the second degree, for which the maximum punishment is up to 7 years and 6 months. Now that I've told you what the allegation is, what your rights are, and the possible consequences, I need to find out how do you wish to respond. Now, let me just go through a series of questions. Listen to them and make sure you understand them. Do you have or do you plan to hire your own attorney?
No, I don't have an attorney.
All right, next question. Do you wish to have the court appoint an attorney to assist you?
Yes.
Okay. Now, there's something else I should have said, and I was on the right track when I told you what the maximum punishment would be. But what I should also tell you is what really can the court do? Ms. Odell, have there been any other probation violations in this case? I don't see any, but
There have been none, Your Honor, and I would note that Mr. Suter's probation will be discharging February 4th on the max term, on the
Oh,
5-year term.
okay.
So he has had none in 5 years.
all right. Mr. Suter, that's important because this is a alleged technical violation and it's your first alleged technical violation. That's important because it tells me that the most I could give you would be up to 15 days. So I wanted to make sure that you understood that.
Okay.
Now, because you told me you would like the court to appoint an attorney to assist you, the court hereby enters a not guilty plea on your behalf. Will refer to the matter to the Wexford Missaukee Public Defender Program, also known as the Indigent Defense Commission, for the appointment of an attorney. The court will also set the matter for an informal hearing. Now, an informal hearing merely means that the prosecutor would be here, you and your attorney would be here, and the two sides would talk and tell me, Judge, we've reached a resolution, or no, Judge, we want a formal hearing. Now, that formal hearing could be conducted 30 seconds thereafter, or we could set it for another hearing date. All right. Any questions so far?
I did have one question.
Of course.
About attorney, is it possible if I can ask for Jeffrey Harrison?
Yeah.
Someone who represented me.
I will make a note here on the file. Actually, it's already on there.
Okay,
And it says that Mr. Harrison represented you previously. They will figure that out when they look at the file, and they will most likely appoint you the same individual. Now, that might depend on how many cases he has going on at any given time. But the answer is it appears here on my sheet, and so I would suspect that's who they'll appoint.
alright,
And if they call you, you can always ask them and express your interest.
alright.
So the next question is, Ms. Odell, based upon the fact that this is his only alleged probation violation in the multiple 5 years or 6, almost whatever it is, yeah. Any objection to releasing the defendant on bond?
Not at all, Your Honor.
Okay, Mr. Suter, the court just places you on your own, or releases you on your own personal recognizance, meaning there's no bond conditions. Just make sure you comply with whatever Miss Odell tells you to do as a probation officer. Do you understand?
Yep.
All right.
I did want to note, I saw on my paper about my cell phone number.
Hold on.
It's-
What? I'm sorry, I did not hear you. What was that?
About my cell phone number on my paperwork, it says 231-846-7059.
Mhm.
I know Gavin Stapleton has my cell phone number. It's 386-281-7170.
Miss Odell, did you get that?
I did get that, Your Honor. Thank you.
That's important also, Mr. Suter, to make sure that that appropriate information gets shared with your attorney in the public defender's program.
Alright,
In fact, I encourage you to maybe contact them on your own and get and make sure they have your correct contact number.
okay,
All right. Do we have their phone number? Well, you don't have anything to write with. It's okay, Mr. Suter. While you see Mr. Champion running around here today, he's the chief public defender. You can always ask him for that phone number. All right, if
Okay.
you see him in the hallway. Anything further
I
today?
don't think so.
Great. Thank you, sir. Have a good weekend.
Thank you.